John in Rochester, New York. Hey, John, what's on your mind today?
Hi, Tom. Thanks for taking my call. What I was
Sure.
calling about is a few weeks ago, I believe, there was a guest you had on that was talking about a way to circumvent the Supreme Court by putting into the laws that they pass in the Senate a small line that says this cannot be looked at by the Supreme Court. Do you remember that?
Right. I do.
That seems to be like something I didn't hear enough about it because I had to get out of the car. If you could talk about it, or how we can find out more about it, or how we can put it into practice.
Yeah, there have been laws passed that have those provisions in them. In 1981, there were 40 pieces of legislation introduced that had, it's called court stripping or jurisdiction stripping provisions that, and this is based on Article 3, Section 2 of the Constitution, which says, let me actually read you the exact words so that, because I'm all the time paraphrasing it, and we might as well just do it right here once in a while. Article 3, Section 2, the Supreme Court, in all of the cases before mentioned, the Supreme Court shall have appellate jurisdiction, in other words, the final court of appeals, both as to law and fact, with such exceptions, and the word exceptions is capitalized, and under such regulations, and the word regulations is capitalized, as the Congress shall make. So Congress has the ability not just to regulate the court, which they can easily do, with a simple majority vote of both houses and signed by the president, assuming a filibuster doesn't get in the way or something like that, to determine how many members are on the court, what they're paid, what their budget is, all that kind of stuff. So that's the regulation of the court. The exceptions has been interpreted throughout the centuries, and John Roberts wrote a memo for Ronald Reagan about this back in the 1980s, in which he cited more than, as I recall, more than 30, certainly more than 20 Supreme Court cases where the court itself had referred to the exceptions clause and reaffirmed that Congress could control what they could and could not rule on. And this is what the Republicans were really working on during the Reagan administration in the 1980s to overturn Roe v. Wade and Brown v. Board. Because those were the two big hot issues for conservatives at that time was, we'll just pass a law that says that segregation is now legal in our schools and Congress can't, and the Supreme Court can't rule on this. And we will pass a law saying that states can outlaw abortion if they want, and the U.S. Supreme Court can't rule on it. They never pulled that trigger. And the reason why throughout certainly the last century and a half, nobody has ever pulled that, no Congress has ever pulled that trigger, is because, number one, there was a broad agreement that the Supreme Court was generally acting in good faith. And so why, just take a bulldozer into the middle of this, delicate equilibrium of the balance of power among the branches, number one. And number two, because everybody figured that the political price to pay for doing something like that, because it's obviously just a pure, political power move, the price to pay would be terrible. That, if a political party started doing this, this is why none of those pieces of Republican legislation got made into law in 1981, was because the party was just afraid to go there. They were afraid of getting their hands burned. I think now that the Supreme Court has become so politicized by Leonard Leo and the Federalist Society and the billionaires, the dark money billionaires behind the Federalist Society, and this whole network, this kind of sneaky underground network of conservative donors that we've had since 1981. I think now, if Congress was to try something like that, it probably wouldn't blow up in their face quite as badly. Although I guarantee you, it would create a firestorm. It would create a small explosion. And the Supreme Court themselves would probably try to weigh in on it, saying, wait a minute, you can't do that. We're saying you can't do that. And then Congress could pass another law saying, no, wait a minute, you can't say we can't do that. We're going to provide another exception. And
it does at this time when we got a lot of things that are 70% that the people want and the government's not doing it. It's the time.
Yeah. And I think that it's a very similar time to 1937. From 33 until 36, Franklin Roosevelt passed a whole bunch of great New Deal legislation, and the Supreme Court knocked down a bunch of it. They passed a law saying that there was a minimum wage. The Supreme Court knocked it down. They said they passed a law saying that children couldn't be working in factories. The Supreme Court knocked it down. They passed a law that gave the right to unionize. The Supreme Court was preparing to knock it down. They passed a law, giving Social Security to people. The Supreme Court was preparing to knock that down. In the 1937 session of the Supreme Court, they were going to be looking at those two in particular, those two pieces of legislation that were the cornerstones of the New Deal. And they had just knocked down in 36, they had knocked down the Industrial Recovery Act, which provided all kinds of worker protections and subsidies and all kinds of things. And so when, in response to that, Franklin Roosevelt said, okay, we're going to pack the court. We're going to use the regulation and exceptions clause of Article 3, Section 2, and we're going to regulate the court by saying that anybody on the court over 70 years old, all of them together, there were 5 people on the court at that time who were over 70. Those 5 people they all become justices emeritus, and collectively they have 1 vote, and then I'm going to add 4 more people to the court so that we're back up to 9 votes, even though it would then be, 14 people or thereabouts, and or 13 people. And, and eventually the old guys will retire or leave or whatever they do. And the public pressure from that, the public was largely behind Roosevelt on this. The Republicans were yelling and screaming. They came up with this phrase, court packing, as a pejorative, as an attack on Roosevelt. But Roosevelt almost certainly would have won that had Justice Owen Roberts not flipped. He decided that he was, he responded to public pressure, basically, and said, okay, we're going to leave these laws intact, and we're not going to tear them down, and we're not going to go any farther, and it's all good. And the Supreme Court started upholding the New Deal, and so as a result of that, FDR pulled back. Now, I would say that probably it'll play out something like that this time, whether it's packing the court, expanding the court, or whether it is trying to pass legislation that has jurisdiction stripping or court stripping in it. That probably it won't become law. Neither one of those things will become law, but they will have the impact of influencing the court. But maybe not. I don't know. And there's also the possibility that Clarence Thomas will resign and Joe Biden will get a Supreme Court nominee. But, who knows? I mean, it's just like so many wild variables. But that's the story, John. And I hope that gives you the background that you're looking for. Thank you very much for the call.